Now, President Cyril Ramaphosa's application for direct access to the Constitutional Court to take the Phala report on review was denied today. The Section 89 panel report, compiled by 3 judges at the request of Parliament, found he has a prima facie case to answer regarding the theft of US dollars from his Phala farm in February 2020. However, given that Parliament voted against adopting this report in December, which essentially stopped any impeachment process in its tracks, is the case now moot? Well, I'm joined by constitutional law expert, Advocate Selby Makgotho. Advocate, thank you so much for joining us. Am I right that the Constitutional Court today basically said you're knocking on the wrong door by coming to us?
Good evening, Sally. Thank you very much. Indeed, what the Constitutional Court had said was to the effect that the matter is not ripe for hearing at the Constitutional Court. What this primarily entails is that he still has an option. The option that is immediately available is to go back to the lower court, which in this case will be the High Court in the Western Cape. Because the law of civil procedure actually allows that the respondents, or where the cause of action had actually arose, is where the matter ought to be heard. So in this particular instance, the president's option would be in the High Court in the Western Cape. But I think we also need to check that this matter has actually not gone far as yet. The merits of the case have not yet been determined. And what this primarily entails is that there are 3 stages that are involved here. The first step is actually that once the motion is submitted in Parliament, the parties, the Speaker actually could then convene an independent panel to essentially look into the prospects of going into the other stages, which will be to adopt an ad hoc committee. So we are not yet at that stage. An independent panel has been constituted, made its own findings, and unfortunately, the Constitutional Court did not agree to be the first and the final arbiter in this particular matter.
Yeah, so my understanding is that when Parliament voted not to adopt that report, it stopped the second part of this potential impeachment process going ahead. So the parliamentary process is, my understanding anyway, is that it's dead in the water at the moment. But in terms of a legal review, the President, as you've explained, could then take that report on review to the High Court, which would be the High Court in the Western Cape. Do you think that's a wise move, bearing in mind that surely the issue is moot now because it's not going to go any further in Parliament?
Well, that is actually the constitutional right of the president to do so in any given situation. But as you will recall, Sally, there was a 2017 Constitutional Court decision in the matter between the economic freedom fighters versus the Speaker of the National Assembly, wherein the court was primarily called, the Parliament was actually invited to develop the rules and the processes relating to the impeachment processes. So what we are seeing now is actually a very good constitutional test, wherein actually the constitutional democracy is at play. But one of the things that actually what you have actually said that had not yet happened is that the Parliament has rejected the report in question, and therefore the process could not have moved to the establishment of an ad hoc committee. But it is also important to understand the significance of the Section 89 panel in the context that the 2017 process had actually given due process to this particular matter in the sense that it was not independent. So if you remember, it was chaired by the Minister of Police at the time. So its independence was hugely compromised and subsequently questioned. So it's very important that there is an independent person in the form of the former Chief Justice who had gone through this. And I think that is actually what gives credibility to this process.
Okay, I wonder if you just explain that in a little more detail. I don't quite understand what that means exactly. But essentially, unfortunately, we seem to have lost our guest. No, he's back. Okay, Advocate, are you back with us? I think we lost you momentarily. You know, you were explaining the president's option now is to go to the High Court.
Is this a load shedding?
You know, it wouldn't surprise me. You were giving me an explanation which I didn't quite understand, so I'm going to ask you to break it down for someone who doesn't understand the law completely. You mentioned a 2017 case. I'm not sure how that relates to what the president was trying to do, which was to gain direct access to the Constitutional Court. He essentially wanted the Constitutional Court to review this Phala Phala report, which he believes should be completely, declared basically illegal, that it was a badly put together report. But he was denied that opportunity today. So explain this 2017 issue that you were talking about.
Yeah, no, thanks very much. I'm sorry we lost each other for a while. But the significance of the 2017 judgment relates to the manner in which Parliament ought to have acted in as far as the establishment of the processes, the laws that actually need to be put in place on a particular matter, such as where the impeachment process comes into issue. It is very significant because then for the law students of the law community, or even the South African in general, it does give hope that the credibility of the Section 89 report panel, the panelists themselves, were independent. So it is very good that actually Parliament has seen the significance of having independent people, the judiciary in the main, coming into the picture to come and give proper clarity and context to the work of Parliament. So there is no issue relating to the independence or whether the panel itself was compromised. As compared to the 2017, where I think the ministers were the ones who were leading that panel, so it ended up with questions relating to its credibility.
Okay, Advocate, thank you so much. I understand what you're saying, is that actually it's really significant that it was 3 independent judges. There's no hint or suggestion of any kind of interference in any way. Nevertheless, the president now could decide to go to a lower court and to try and take this report on review, which he believes is not right in law. If he does that, doesn't he risk it backfiring, that possibly he's granted that review and that a lower court looks at it and says, actually, there aren't many holes in this document. It looks like it's been fairly well put together. Because the document was very clear. It was looking at what they have on the surface of what they've got. And they concluded that there's a prima facie case against the president. If the president decides to take this further, doesn't he risk it actually backfiring?
I don't think so that he runs the risk of it backfiring. Remember, the court will now have an opportunity to look into the merits and look into whether this particular case is ready to proceed to the next level. If ever he is not happy with the outcome of the High Court, he can still go to the Supreme Court and ultimately to the Constitutional Court, which today has rejected the application. So that is where the matter actually belongs. That is where the jurisdiction in this kind of particular circumstances reside. So I don't think there is any risk as yet, because the president's mind, the contents of the Section 84, but in particular, if you have gone through the Section 89 report, it the main issue that he seems to be having gripe with is in relation to the prima facie evidence vis-a-vis the sufficient evidence. So the High Court is properly placed to look into that, to adjudicate into that, and make a proper determination, because the first stage that happens in the context of an impeachment, if any, is that there should be sufficient grounds towards that. There should be sufficient evidence. The soil should actually be fertile. So at this stage, the president's argument, as stated in the affidavit, is that he is not quite sure whether the Section 89 report had actually determine the sufficiency of the evidence or the prima facie. So those are some of the things that the High Court is fully empowered and can look into independently. And at the end of the day, a proper finding will so be made. If whatever way it takes, the Constitutional Court can still come far much later in case there is still a need. But at this stage, the ball is now in the court of the High Court.
If indeed the president's lawyers decide to go that route, we know that they're studying the decision by the Constitutional Court today to decide their next move. But thank you so much for giving us clarity and also for bearing with us as we try to cut through the difficult signal, probably due to load shedding. Thank you so much, constitutional law expert advocate Selby Makgotho.